we'll talk about employment at will, some of the federal and some state laws related to employment, and look at employment discrimination briefly, including Title VII. So as you read the chapter, as I know you all did over this past weekend, you learned that employment at will technically means what? Fired at will, yes. Right, yeah, you kind of could be fired at any time for any reason, right? And you could, without reason, yeah. Or without liability, yeah. Or you could what? Quit. No, I wasn't quitting. Quit at any time for any reason. And as it says up there in the second bullet, while technically that might be what employment at will means, it's not the case these days that you could be fired at any time for any reason without liability, right? Because of the amount of state and federal regulation, it's much more difficult for employers to fire you unless you say something on a recording that they don't like. I love my employer. So, I mentioned a number of exceptions. Some of them are statutory, some of them are judicial. In other words, there are some cases that have been decided over time that say, well, technically you really can't just fire anybody for any reason. And those cases have been categorized into the three on the next page here. Kind of contract exceptions, tort exceptions, public policy, and there's another one down there, but that kind of covers it all. Employment at will means not a contract employee. How many of you are employed at will? Okay, how many of you are contract employees? The vast majority of you are unemployed, apparently. Yeah. All right. So if you don't have a contract, you're employed at will. And so it's kind of weird to see the first exception up there be the contract exception. Yes? Is the union employee like a contract? In a lot of cases, yes. I am a union employee, and I have a faculty contract. It's out there online if you want to go look at it.
What's the exception, like you can be fired within like 60 days? Do you know what I mean?
Well, there might be several exceptions related to that. One might be some type of internal policy relating to like what do they call it, probation period of time. But there may be some statutory requirements depending on what kind of job you're talking about. Yeah.
Would that be like some careers require you to do like internships and stuff before you can get a degree for it?
No. So what this has to do with, the general rule is you could be fired at any time for any reason, but this has to do with exceptions that say you can't be fired. And this one in particular has to do with the idea that there isn't an express contract that you're under, but that you shouldn't have been fired in the way you were, or you shouldn't have been fired for that reason because there's an implied contract. And what was the example they used in your chapter? Had to do with procedures. Yeah, we're not talking about express contracts, though. We're talking about the idea that even if there wasn't an express contract, that somehow something was implied that should happen to you before you are fired. So if you want to open your book and look. What's that?
Like a written write-up?
A written write-up.
Like McDonald's if you made it.
Yeah, I think that's where the example is heading. If you look in the book under exceptions and the implied contract exception, I believe there's an example regarding, basically having a policy manual or something that says you're employed at will, but before we'll fire you or take action, we'll take these steps. So how many of you have a type of job where they say the first time you mess up, we'll give you a verbal warning. Next time, you're written up. Third time, you're out of here, right? Now, there's always going to be some cases where it depends on what it is, right? You might be like, where's my verbal warning? And they're like, not for that. You're out of here. To keep you here would be a liability for us. But the example, basically is, let's say everybody in your company, when they went to fire them, they followed this process. Documented verbal warning, in writing, dismissal for a few days, and then discharge. But then they get to you, and they just say, we don't like you, you're fired. Right? So you raise this contract exception, this implied contract, that may be something you were told, perhaps in a policy manual, which isn't your employment contract, wasn't properly followed before you were dismissed. So that's one theory, that they didn't fire you according to their own processes or what they implied they would do before they fired you. The next one is the tort exception. This is kind of how you're fired, and it relates to the wrongful discharge there at the bottom. Let's say you're all my employees. Wouldn't that be fun? You hurt my feelings. So let's say somebody stole some money. Right? What would be I call you all into this meeting today here. What would be a good way to handle it and a bad way to handle it?
Well, if you have cameras, you know what I mean? If you have, places.
Hey, you're not working in here anymore, so I don't even think you should be able to talk at this meeting.
Yeah, if you suspect them, you should have
Evidence, maybe. So perhaps the best way to handle it would be to take the person off to the side and not accuse them of anything outright, but ask them, maybe do that with everybody instead of singling somebody out. What would be a bad way?
Why did you steal that money?
Right in front of everybody. Why did you steal that money? Right? Because what is that called when you accuse somebody of doing something that they didn't do and it harms their good reputation? Right. It's a type of defamation. So it may later turn out that they didn't actually do it. Has anybody heard of cases like that in the news where somebody gets wrongfully discharged for something that turns out they didn't do? Like?
There's a movie coming out about something like that. Like this guy didn't kill somebody.
Was accused of killing somebody?
Yeah, but his sister's like, oh, you didn't do it. After 43 years of prison, he was free because he was wrongfully.
Oh. And lost his job and various things. What's that?
That's not, I can't remember what
Oh.
I think Hillary explained something.
All right. There was a lady who, and maybe I've used this example before, but she was accused of stealing the night deposit, and she went and deposited the money, and it got stuck behind the drawer in the bank's night deposit, and the bank claimed they didn't get it, and the employer didn't have it anymore, so they said they fired her for stealing the money, and the bank said she must have because they didn't have it. And then after she was sentenced and was incarcerated, the bank came out and said, oops, we found it. So meanwhile, she's lost her job. She's been imprisoned, and the community knows of her being accused and convicted of stealing. So, if you were in that position, wouldn't you want to sue the bank, your employer? Yeah. How would it be to go back into that community and say, yeah, I know you might know me as a person who stole the money, but it turned out that wasn't true, and the bank just made a mistake, and everything's cool? Right. That would be kind of hard. So, yeah, those kind of situations do happen. Another situation, there was a restaurant where one of the employees was accused of going out into the parking lot and doing things with her supervisor in the car, and and was fired for it, and then it turned out that someone else just didn't like her, so they made up the story about her doing that, and the company didn't adequately investigate it at all. So those kind of things do happen. Public policy. This is kind of like maybe there's not a specific law on it. Maybe there is, but it would just be bad public policy. We just don't want people willy-nilly firing people for these types of reasons. They mentioned whistleblowing as an example. Good public policy says if your employer is violating the law, you should let somebody know. Right? You shouldn't participate in it, and you should let somebody know that it's some type of illegal activity. But I don't know. What would it be like if you got fired for blowing the whistle and then you got your job back?
Like
It's awkward. Right? Yeah. There's been situations where, huge scandals came out and some employees came forward and there was retaliation taken against them, and then they want to have their job back. Of course, they may not have a job anymore because there might not be a company there anymore.
No, a lot of them were disbanded because of the new accounting law.
Right. The responsibility to disclose things that previously they thought they weren't supposed to disclose. So if you're supposed to create shell corporations for your customers, then it's kind of not the ethical or legal thing to do. I was trying to think of another example of that one. There was a pilot who kept telling his employer, airline, that the planes were unsafe, and then one of the planes went down and killed a bunch of people, and he reported it, and he went on the Today Show or some TV show in the morning and said, I tried to warn them, but they didn't listen to me. And he came back to work, and they tried to extensively search him, which you've ever seen a pilot go through a security checkpoint and get extensively searched. So he claimed that it was retaliatory and that they fired him. And he won, but again, I don't know if you'd want to go back and work for some place like that. But wage and hour, we're going to talk about a series of laws at both the federal and state level. You don't have to memorize all the names or the years they were created. This will give you an idea of all the different types of laws related to employment. Child labor, some of you probably, I don't remember when I was a minor. You guys probably might. Did you have any restrictions in terms of the hours you could work, or? Okay, so did it matter whether you were going to school or not? Yeah. Work more when you're not in school. How about the hours that you could work before you get a break? Didn't you have, was it 4 hours or something, and they take a break? I still know some employees who are like that, but how about the type of jobs? Does anybody have a limitation on the type of job they can do, or? I can see serving alcohol, but you couldn't drive pizza? Yeah.
Now there's even certain pieces of equipment in restaurants that minors
Meat cutters would be bad. Somebody in last class was telling me that even, like not so much the operation of them, but if you tried to clean them or whatever, that you could hurt yourself pretty good on them. So, yeah, makes sense. It might burn themselves. Yeah, so, or just how many hours in total a day you could work. So there are also some exceptions, like in the agricultural area or family-owned businesses. Usually I'll have someone who says, I grew up on a farm and my parents worked me to death and didn't care how old I was. There they are now on the farm. The Prevailing Wage Act, Davis-Bacon Act, minimum wage. What's minimum wage now? $7.35? Seven what? $7.40?
It's a little higher than that.
Yeah, is it?
$7.40 less than
$7.50? Anybody get $7.50? Auction there. I heard it's different for minors too. Like in Michigan, there's actually $1 less or something at minors. That's got to be interesting. Like doing the same job beside somebody and getting paid $1 less minimum wage. Some local municipalities actually have a higher minimum wage. Like they want to attract workers, so they say.
Mine was $8.50. Then after 90 days, you got an extra $50.
Yeah. So, and then there's some rules related to overtime in terms of, generally if you're a salaried employee, these aren't going to apply. The number of hours you can work in a week. Usually in making a distinction between whether somebody is an executive or an hourly type employee. Layoffs, there are newer laws related to if you're going to do a layoff, providing notice, how big of a layoff you can do, and if you fail to provide the notice or comply with the other parts of the statute, remedies that are available. And you'll notice on some of these that the penalty can get pretty steep per day. In this case, $500 plus back pay plus medical benefits, unless if you fall under the statute, you comply with the statute. And then FMLA, Family Medical Leave Act, which a lot of people think of as the pregnancy statute, but that's a small portion of it. It doesn't necessarily have to even be you. As you look at the statute, this is a summary of what it says. Could be a spouse, child, parent, and close family member who suffers from a serious medical condition. By the way, never tell your wife that she suffers from a serious medical condition when she's pregnant. She doesn't like that very much. But notice also that it says employers with over 50 employees to provide unpaid leave to employees. So if your employer even falls within the statute and they're required to give you this leave, there can be lots of policies on what is a serious medical condition, but in the end, if they do have to give you the time off, they don't have to pay you for it. Although I know people who get paid. I took it once, I got pay, but I had to use my accumulated leave, vacation, whatever. When we had our first child, I took it off, and my wife said, go back to work. It's like taking care of 2 kids. So. And the other part of this is getting your job back, right? So part of it is getting leave to take care of the situation, but if you do, that you shouldn't be punished for that, that you should be able to return to the same or similar position at the end of your leave. When I mention OSHA, usually a few of my students have experience with OSHA or MyOSHA. Anybody ever dealt with that? How have you?
Not a hard hat, construction zone.
All right. So construction zones, lots of requirements. How high you can be off the ground without being secured, or what are some other ones?
Not protected railing around stairs. I had that was a factory turned into World Economic Housing World.
Oh, okay.
They didn't tie off an orange fence, a stairway opening to 20 South Street door.
Wow.
That was a big infraction.
Yeah. Yeah, I think that's important to point out, is that, some of this is proactive. Here are the rules, abide by the rules, and you're subject to inspection where somebody will find out whether you're complying with the rules or not. But the other part of this is that if something does happen to somebody, that you may have some record-keeping requirements, and they may come back and cite you afterwards for not being in compliance with OSHA or MyOSHA.
Well, and they also do have some fines.
Yeah.
So it's a
Anybody work at Meyer? I've heard that that's a pretty common thing, like, come in and find a ladder that's leaning up against something or different things. And
Well, I work at Menards, and we have the pallets that our freight comes in on.
uh-huh,
And I know that we got sued by some lady who had tripped over
uh-huh.
one of the
And then that,
pallets. So now we have to tip them up against the thing, which is typically against OSHA. So I don't know how that works.
well, it seems like you'd want to do something that would prevent you from having civil liability and liability on this, so maybe there's another solution that wouldn't involve violating some other law. Tipping them up doesn't sound like the best thing.
Well, you like
Not
to
that I'm
put it
giving you
on
any
the
advice. That's
side,
what
so
to do.
it's not on the ground.
Right. Well, I mean, leaving crates laying around on the ground doesn't sound good.
Well, we have like our stuff still sitting on it, and then when everything's off of it, we're just required to tip it up so people know that it's there, I guess, instead of being like out of your line of sight when you're walking.
Well, it's harder to see the crate if there's nothing on it.
Yeah.
Yeah.
Wouldn't you, like, why would a customer be walking around in a lot of those areas?
Well, they're on the back aisle, like where I work. We have a lot of our doors back there, so they want to look at the doors or.
Customers walk anywhere. They climb anywhere. They do, really. You find them hanging off of things. You got a ladder that says don't climb on it, and they're climbing on it. Or they're anybody work in automotive, like they're walking through the garage, or they're walking in back areas they're not supposed to. So, yeah, they do stuff like that. And kids! My kids, you don't watch them. They're climbing up whatever. So notice the last one. Employers with 11 or more employees are required to keep records. So if somebody is injured, they need to keep a record of when and how it happened. There's some statutory requirements. How many employers do you think have less than 11 employees? Most. Again, in the United States, there's a whole lot of small businesses who have very few employees. So the idea is that this should not impact to a huge amount small businesses. Not that you don't have to comply with OSHA or MyOSHA if you have less than 11 employees, just you don't have these additional administrative requirements. Now, of course, your employees keep getting hurt the same way over and over again, and maybe something is wrong. And employees will get you into trouble all the time. Like, the number of times I've heard about these press operators where you have to have your hands on both switches in order to operate the press, and the employees have rigged some way to make sure they only have to do it with one hand. Well, guess why they have the two-hand operation? So that your other hand isn't stuck underneath the press. Sure enough. Well, how did that happen if there was a dual safety? Somebody rigged up or removed, you got meat cutters or whatever, remove the guards. It's just a hassle. It's hard to take care of and clean. Yeah.
After freshly that happened, we had an employee reach in to get their bottle injector unstuck.
Oh, ouch.
Took off the tip of his finger. Well, they had to shut the line down and investigate. So they found that it had been documented that this certain piece of equipment was malfunctioning and the safety door was broke, so employees could stick their hands in. They tried to fire the man and couldn't because it was their error that they fixed the machine.
So, yeah, don't remove safety features. And if you know of something that's a hazard, get it fixed. All right, state workers' comp law. Notice I said state. Did anybody catch that I said state? So we've kind of switched gear from federal law to workers' comp law, which is handled at a state level. And the two biggies, if you were to boil that down, you get workers' compensation when you're injured on the job. And so those are the two factors that you're usually quarreling over, is how did the injury happen and where did it happen? So if somebody intentionally inflicts their own injury on the job, or somebody has an injury off the job and then tries to come and claim it's on the job, those are the problems. Then there's kind of in between, like where the question is it really on the job or not? Because sometimes the situation is not as clear as somebody putting on the job or off duty on it. Well, that's why a lot of employers do that. Like when you wear your uniform, when you can punch in, and if you are punched in, that's the time you're on the job. So that liability, I think, is probably one of the biggest issues, is why they have those type of policies. Certainly when they want their employees there when they're supposed to be there, but they also don't want to be liable when they're not on the clock. Where I've seen it come up is, like driving to and from or during work, whether that is part of employment. And it could or it could not be.
You mean like pizza delivery people?
Well, that would be, I would think that'd be part of someone's job, right? But for me, driving into work to teach or driving home after work, I don't think so. Right? Or if you make deliveries, I think that would be part of your job. But it's also possible that even though your job isn't driving around, that you may need to drive around as part of your job. You're on a trip somewhere, you're whatever. And when I ask for leave to go somewhere from my employer, I have to be very clear about whether I have insurance, whether I'm going to be driving, whether this is on the job or outside my work hours or things like that. So, and the other one is that comes up is like, what if you're at a remote site? Does anybody work like out in the field? It doesn't have to be a field, but somewhere else. So shouldn't that be part of your job? I mean, not everybody works in a cubicle in the headquarters. Some people may work at a remote location. Or the other part of it is, though, how the injury occurred. If you negligently injure yourself on the job, that's usually covered. An employer might say, well, it's not our fault. But you say, it wasn't an intentional act to injure myself. What if your coworker does it? Again, your employer could say, it wasn't us, it was them. But usually, unless you ask your coworker to injure you, that would be covered too. Let's say you work for Consumers Power, and Consumers Power says, go out to that site and trim some limbs. And so you and your coworker go out, and your coworker is buzzing with a chainsaw and didn't understand the instructions and trims your limb, right? So they might say, look, didn't follow our directions, not our fault. Coworker did it, coworker negligence. But that would be covered under workers' comp. The theory of all this is that you shouldn't have to sue your employer directly while you're working for them. Imagine how awkward that would be to come in the afternoon and say, good seeing you in court. Sorry about that whole having to sue you directly thing. Your employer may not be too happy about that. So, that's right. No hard feelings. All right, and most laws in the states require most employers to carry workers' compensation insurance. Don't ask me when they wouldn't be required. I wouldn't have a clue. Not an area of law that I've practiced in. Workers' comp is a big area of law. Some attorneys practice exclusively in that area. Workers' comp, bankruptcy were not things that I ever got involved in too much. Like the weather, it almost makes you want to gouge your eyes out. I tell you what, you sit in bankruptcy court for a day. Tie your hands down, because if you find a sharp object, your eyes are coming out. I would go there occasionally because I would represent a company who was a creditor or was somehow had an asset that might be part of somebody's bankruptcy estate. I couldn't imagine actually being there. Oh, so depressing. I mean, the subject is depressing, but it's boring. Federal bankruptcy law is boring. All right, income security. So there's a variety of different types of income security, from what you get when you get old, whatever old is, I guess that's relative. Social Security, which some say you won't ever have to worry about. I don't know. Medicare, in terms of based on age, whether you can get health insurance, versus Medicaid, which has to do with income. Private pensions. There are specific types of private pensions, railroad pensions, all these things, even unemployment insurance. So I had to apply for unemployment once because my mom fired me. Did I ever tell you that story? My first job at Kentucky Fried Chicken, my mom was my manager. And she kept telling me to do stuff, and I kept telling her no, which children are prone to do, right? I was in high school. And one time she told me to do something, I said no, and she said, "You're fired." I said, "You can't fire me, you're my mother." She said, "I'm your boss." So then then they had local unemployment offices. I guess they handle it a little differently now. And they said I couldn't collect it because I refused to obey a lawful instruction from my employer. I'm like, "But it's my mom." We don't care. So, yeah, now I understand it's a little more automated, and that there's one up on Plainfield. There's like maybe more regional sites that handle a variety of different things. Maybe you can call in. You can do other things. Yeah, online services, which is a good thing. It was a hassle to go down there, but COBRA, which stands for Consolidated Omnibus Budget Reconciliation Act. COBRA sounds cooler. It sounds like G.I. Joe's arch enemy or a Mustang. But has anybody ever dealt with COBRA? Like having insurance after? That's what I hear. It's like, well, you can have insurance, you just don't have a job to pay for it, and it costs a lot of money. So, but some say that it's better than not having any. If something happens to you and you don't have health insurance, that's pretty expensive too. So, the keys are that, it discontinues benefits whether you're voluntarily or involuntarily separated, unless the separation was involuntary for gross misconduct. And there's another one of those requirements at the bottom there. The employer must comply with COBRA if they have more than 20 employees. Group health plans, including the ability to continue health coverage somewhere else. And you might be more familiar with HIPAA in terms of disclosure of medical information, some requirements under that act. Employee privacy rights. The Constitution doesn't go away with employment, so there's still a right to privacy that isn't actually listed in the Constitution, but is implied by the Constitution. And there's really quite a few areas of employment which are not, where you don't have a reasonable expectation of privacy. Like if you think what you put in your desk or send out through your email at work is private, it's not. There's a good chance whatever you do on your network, whether it's your own private account, Facebook, whatever, that's monitored. Sometimes when I finish this class, people scramble out the door, run back and remove whatever. Somebody in my last class said, "I'm going to go remove those tweets," or whatever they had posted. I said, well, once it's out there, it's out there. So, gotten a lot of people in trouble. People who posted things either through their network at work using employer equipment to post things or send things, or even being at home and saying nasty things about your employer. Yeah?
I know someone who got fired from KFC because on his Facebook, under like the job description, he said, "I'm the one who's supposed to
Oh, just supposed to be a little bit of humor,
Yeah.
but not taken so, yeah. Yeah, there are people who think, as long as I'm not at work, I can say whatever I want. But there's a really good chance that employers are on Facebook, often your boss, or if somebody's considering you for employment, they're looking at Facebook. So. Well, there are some people who say it's best to have your own personal account and then have another account. And, you need to be careful about that. Actually, there's Facebook policy around having 2 accounts under your name, but that's an alias or some other unrelated thing. But, yeah, there's been a number of cases about people who got fired for saying bad things about their boss. Anybody ever gotten an email and thought, man, I can't believe this idiot, and want to reply to somebody and say, don't you think this person's an idiot? And then panic because you may have hit reply all? Oh, come on, you've done it. You've never sent an email to somebody that you didn't mean to send? Or text somebody, yes.
I was like thinking about them,
Right.
talking about them, and
Uh-huh.
I sent it to them thinking
Oops. I didn't want you to know what I really thought of you. Yeah. So this can be a problem. Or teachers who say bad things about their students. There's been a recent case in the news. Or vice versa. I would not do that. What, are you looking online right now? Oh, you're like, oh, yeah. Whew. Yeah, I'm apparently lazy. And not hot. So, no. It was revoked. It was revoked, yeah. Yeah. Uh-huh.
It was so funny. She goes, well, apparently 10 years ago I had the chili, but it's
Right. Yeah. Well, mine was removed. They found out it was me, that I gave it to myself. No. Using that alias account. No, I didn't. But every once in a while, whenever I really took off a student, I go and look, and sure enough, they've posted something there. So I don't look at it that often. But one guy got mad because I used a question, much like I just did on the practical exercise that I had already used. He said, this guy's lazy, don't take him. He uses stuff right out of the book.
Aren't you the only business law that's up there?
Uh-uh.
Oh, you're not?
No. Oh, there's other ones. There's quite a few now. Yeah. That wasn't your only choice. Now, 12 weeks into the course, you find that out. Crap.
No, I was looking at online. I think you do online too.
I do, but I'm not the only online business instructor, too.
Well, that's how you look
Yeah.
at it. I know, right?
Hard to believe. So, yeah, you should be careful about that kind of stuff. It's not just that somebody is necessarily snooping into what you do. It could be equipment that someone else gets access to. It could be even monitoring performance. Like, think about anybody have cameras at work? Are they on your customers, employees, or both? Yeah.
They're kind of on everything.
Right.
It's outside.
Okay.
They monitor everything, so it's more tight when we're not there.
Oh, okay. Okay.
People come steal stuff off those.
Right. Which could be employees too, right?
Yeah.
Yeah, I mean, it's possible employees could steal from their employers, or just monitoring what employees do. I mean, it's hard to be in every place at every time supervise employees. That's why you call someplace and they say your calls could be monitored for quality assurance purposes. They like to listen in, too. Did you say you have cameras? Why? Yeah. Ooh, I didn't know that. Uh-huh. Yeah. But there's probably been a lot of loss.
I don't hear a lot of it,
We'll change. I'm recording. We'll change the name. PUS, PSU, UPS. We'll say it differently so it doesn't sound like UPS. Right.
Some guy once stole a lottery ticket. 'Cause it says on the box.
Oh my
"Please
goodness.
pay lottery ticket."
So somebody was sending in their winning tickets.
No, the guy went to like the Meyer down the street and he won like $50, so he took it in there. But at gas stations, they code the lottery ticket once it's just.
Oh, so he
So
turned it.
wasn't-
Oh,
It
I
wasn't
gotcha.
activated.
It wouldn't have worked.
Yeah, and she's like, give me a second, I ran out of bills, and she called the cops on him, and 2 minutes later, he was arrested.
Oh man. Yeah, so employees can do that kind of stuff. So you work in a bank, you know, there's cameras on tellers as well as customers. Yeah? Getting a weird look on your face? One I never quite understand is Steak and Shake. You know, so you walk out the door, there's a ruler on the door, like your height. So, I mean, I imagine it's security in case you get robbed because they're on high traffic areas where people might run in and steal a shake or something. But just
Still at house time, hiding in there, the sheriff's walking around looking for him. And, the outer one fell, you know, can I help you? And, oh, we're looking for somebody to do a half hour doing nothing.
oh, they were hiding.
He came out and handcuffed him.
Oh, so instead of somebody running out, they were hiding in. All right. Well, probably as a customer somewhere you've, well, it looks like I've even put the slides to sleep. Sorry about that. Come on. Skittles. Skittles, how does that play into this? So, other implications, other types of monitoring of employees. This could be when you're screened for employment or during employment. Anybody ever been tested before employment? I needed it for the military, so they'd know what my parts belong to. Like if you get blown up or something, then they check and they go, oh, this belongs to him. So DNA, genetic testing, drug testing. Yeah. What's that? Yeah, fingerprinting. Anybody else? Criminal history checks. Anybody ever been polygraphed? I've been polygraphed. How about the old background investigation? Anybody ever had somebody come out and interview your neighbors and past employers and stuff? What's that? Yeah. Yeah. Yeah, it's really weird. I've had it both ways where my neighbors have been interviewed about me, and that was just yesterday. No. And I've had to sit through interviews by FBI or whatever of my neighbors. And they're like, so is the guy a real liberal or I don't know. I mean, what's that? Uh-huh. Yeah. Yeah, weird. Maybe it's the same guy. No, I mean, they're just weird stuff. They're trying to get you to, yeah, they're trying to get kind of a reaction from you and then pursue it, but I don't know. So yeah, I've had them all. But HIV testing. Yeah. Well, I suppose I actually had the testing, but yeah, that could happen during employment too. If you've ever been somewhere where there's been an accident or something, that's pretty common for somebody to come along and drug test. There's a train crash, bus crash, airplane crash. Testing. immigration laws, it's funny how the climate has changed in just the last few semesters that I've taught this. We talk a little bit about unions, and it seems like these days there's a whole lot of climate around unions, like in different states, and the attitude of people towards them. And also in the area of immigration. I mean, not too long ago you wouldn't have think that's such a huge battle between the states and federal government, but Arizona tried to pass some laws. And it's not always border areas that this is an issue, right? Even where I live, it's not uncommon during the growing seasons to see police officers out in the field asking people questions. They use a lot of migrant workers. So one of the issues that, that's kind of the, whether somebody is a legal or illegal alien, but there's also the whole issue of whether employers have knowledge of that or not. On the next slide, I think it's the next slide, yeah. There are some requirements in terms of verifications and what documentation workers are supposed to have, and often companies get themselves in trouble because they say they're not aware that they're hiring or working with people who are illegal immigrants, but the type of behavior is like paying in cash, not requiring proper documentation, not providing proper documentation. Title VII. Title VII prohibits discrimination in employment based on just those categories. There are other laws we'll talk about under other statutes, but this one relates to race, sex, color, religion, national origin. I did not write the next sentence. Just strikes me funny when I read it. But what it means is that if you're discriminating based on pregnancy, you're discriminating based on gender. Because so far only one gender has become pregnant. Although there's some news stories about that, refuting that. So, you have the Title VII statutes, and then you have courts deciding cases, and over time the courts have said if you're discriminating based on pregnancy, you're discriminating based on gender. And this isn't just in hiring. This is in employment and in discharge from employment, and may include, like in areas of religion, reasonable accommodation of religious practices during employment, which could mean anything from time off, dietary issues, break time. All those things could relate to whether you're giving employees reasonable accommodations. Title VII is enforced by the EEOC, the Equal Employment Opportunity Commission, and that link in the slide will take you to their site. Here's one of the biggies. Most people, I think of discrimination as entirely intentional. Like you're only responsible, you can only be accused of discrimination if somebody can establish that you intentionally did it. But that's not the case. There is intentional and unintentional discrimination. Another phrase for intentional discrimination is disparate treatment. You're treating people differently in your hiring practice or employment practices. If you're alleging intentional discrimination, you need to show that you're part of the protected class, which we mentioned those classes under Title VII, that you applied for, were qualified, and rejected for a job, and you went on to seek employment somewhere else. Once you do that, the burden shifts to the employer or potential employer to establish some other reason why they made the decision that they did. I think most people are pretty clear on that one. It's the disparate impact or unintentional discrimination that I think is a little bit of a challenge. The idea is that you can't really point to a single factor where somebody intentionally discriminated against a group, like you didn't come out and say, we're only going to hire this race or this gender, or we asked this improper question on a job application or something. But the composition of your workforce reflects that some type of discrimination must be going on. So even though you don't just exclusively hire males, your workforce is entirely male. Right? So the impact of something is causing that effect. Now, there might be some other reason for that. There might even be situations where that would be appropriate. Can you think of a situation where you should only hire males? Or only females watch it?
For male adopted and
Right. Male model, in some situation where you only want males. Sports has been kind of a weird one, or female model. It seems like there are some situations where you're going to have one versus the other. Although there have been cases involving both Victoria's Secret and that other family restaurant place. I just love that place calls itself the family restaurant. Anyway. So under Title VII, there is intentional or unintentional discrimination, and that could not only be the actions of a company, but it could also be the policies. So as you make hiring decisions or promotion decisions, they need to be based on realistic qualifications for the job. It hasn't been successful to argue that you have to be of a particular race in order to be qualified for a job. But some of those other situations we mentioned. And there are some cases where people allege reverse discrimination, discrimination to undo past discrimination. We're adopting this policy because the data shows that we've engaged in some type of unintentional discrimination in the past, which opens up yourself for liability with the other group. I think I already mentioned this one, that reasonable accommodations for sincerely held religious practices, ones that won't, when I say reasonable, won't create an undue hardship on an employer. Discrimination based on gender, and there's a variety of laws that relate to fair pay, but in terms of Title VII, there might be some situations where you could prove that it's essential to the job, but generally you should not discriminate based on gender. Sometimes it's not just outright firing somebody. It might be constructive discharge. It says there at the bottom that the conditions are so intolerable it's as if somebody is discharged. It's just difficult to work under those conditions. And that could even be sexual harassment. So there's two broad categories of sexual harassment. One is hostile work environment. In other words, it's difficult for you to work in the environment because there's offensive things around you, from what's on the computer, what's on email, what's on the wall, or what's being said, or quid pro quo, this for that type of sexual harassment. You do this for me and I will promote you or advance you or give you a better job. And it's usually the case that it's actionable when it's severe and pervasive. A one-time situation where somebody says something that's inappropriate may not establish enough pattern for a hostile work environment. It mentions that it permeates the workplace and that it's severe. It's more than just a one-time thing. And then supervisors. So often when you feel you've been treated improperly at work, what do? Go to your supervisor and say, I'm being treated improperly. But what if your supervisor is the one that's engaged in the behavior? So in the example of, that was close, in the example of sexual harassment, if somebody is a supervisor in a position of authority, they might be the one doing it. So you need to have a policy and process in place to go around that person. You don't want policies that say you have to go to your supervisor. And the other thing that can be actionable is sexual harassment is reported and people don't do anything about it. That could be a problem too. There's a variety of defenses, not that it's acceptable to sexually harass, but that, as it says up there, one, the employer has taken reasonable care to prevent and promptly correct any sexually harassing behavior. So putting policies in place, being proactive, acting when there is a complaint, having processes for going around supervisors when that's the case. And the plaintiff or employee was told what to do and failed to follow up and do something about it. Could be a coworker. Also, it could be a customer. In some situations, perhaps it's not something your employer is doing. It's something that you're exposed to as you do your job by customers. Could be same-sex. In the very beginning of suits related to this under Title VII, employers were not taking those type of complaints seriously, and then employers ended up having liability for it. Remedies. So, if there is a violation of Title VII, there may be reinstatement, getting your job back if you lost it due to discrimination, back pay for the time you didn't have your job, maybe even retroactive promotion, and whatever you're out in terms of damages. Discrimination based on age, or the ADA. Notice that it says over the age of 40. Why do you think it's 40? Don't tell me because you think that's when you're dirt old and you're going to die. Why do you think 40? Why not 65 or something? Yes, that's it, because you're going to go out and do something crazy. Is that midlife, 40? Midlife? Yes, I guess it could be. Maybe it could be late life for some of us, right? So, no, I don't think it's the midlife crisis. I think that's a big part of it. I think that the older your employees get, the more chance that they're vested and they're actually going to collect something on their retirement. Or the cost of health care can go up. Plus, it's more expensive to pay experienced workers. So if you got to pay them more, they've got a pension, they're costing you in terms of health care, which isn't always the case. I mean, I know people who are older and healthier than younger people, and you might tend to. But basically, if you get fired and you fall into this group, you might be able to show that you're in that protected age group, you're over the age of 40, you were qualified for the position, you were discharged, and under circumstances that infer discrimination. Perhaps everybody who was fired is over 40. Perhaps there's communications about it or comments that are made. Certainly there's some issues that do come up in terms of what happens when you replace older workers with younger ones. Sometimes the argument is that you do it because the younger generation has more savvy or knowledge in that area or is less expensive to pay, that it's a good business decision. But something to be aware of, Disability. So under the ADA, it says it requires employers to offer reasonable accommodation to employees or applicants with a disability. Disability as defined under the Act. So not what you think one is, but what the Act says qualifies as a disability if you're otherwise qualified for the job or that you hold or seek. And if it is under the ADA, the employer or potential employer has an obligation to provide reasonable accommodations. Reasonable meaning not an undue hardship on the employer. So basically, to prevail, you'd have to show that you do have the disability, you're otherwise qualified, you were excluded, and the reason for that was due to your disability, and the workforce must be more than 15 employees. Some categories, pretty obvious, they are disabilities, and have been cases have consistently interpreted them in disabilities. Others, not so much. Basically, the Act says that it impairs a major life function. So there are lots of situations where you can continue to do your job. This has to do with whether you can do the things you need to do to function, take care of yourself, and that you exhausted any administrative relief that you were supposed to go through the EEOC first. And this, like I said, defines in the Act what a disability is. And it's on a case-by-case basis. Some situations, the courts have just said that's not going to be a disability. For example, carpal tunnel, right? Certainly a lot of workers have that as an issue. But what if you said everybody who has carpal tunnel blanket has a disability? Think of how many people that would be in the United States. That would be a lot. I'm not going to go through all that case law. And I think we've already talked about reasonable accommodations. Oh, there's carpal tunnel as an example here. Let me go to slide here. There's a ton of slides on ADA. Defenses. So these are an argument that perhaps the action could be discriminatory, but there was a legally excused reason for it. So the idea that it is a business necessity, we talked a little bit about that your business requires to be of a particular gender, for example. That it's a bona fide occupational qualification. The example is, how do you teach in seminary if they don't ask you whether you have that particular religious belief or affiliation? So sometimes it's required because that's what you're doing, right? Or seniority system. Yes, maybe this person is this gender and they were treated differently than the other, but it's due to a legitimate, fair seniority system. And one person was promoted because they've been there longer. And then the last bullet up there talks about